Welcome back to the Privacy Legislation in Canada course. We're going to continue this section talking about the Personal Information Protection and Electronic Documents Act, which can be quite a mouthful. So going forward, we're going to refer to this as Pipeda, the acronym for that act. So Pipeda governs the collection, use, and storage of personal information for business purposes. The section we just completed on the Privacy Act talked about the collection, use, and storage of personal information by federal government institutions. This act is about that same information for business purposes. We're going to specifically be focusing on Part 1 of Pipeda. Part 1 is the part that refers to agencies that are in the private sector. So Pipeda is a federal act, which means it was passed by the Government of Canada, and it applies everywhere in Canada. However, there are certain provinces that have passed acts similar to Pipeda, including BC, Alberta, and Quebec. In these three provinces, the acts are similar enough and cover more than what is covered in Pipeda, so the federal government has said that these acts replace Part 1 of Pipeda. In any other province, there may be provincial privacy legislation that would cover the use, the collection, use, and storage of personal information for business purposes, but the federal government has not specifically said that they're strong enough to replace Part 1 of Pipeda. We're going to take a look again at what personal information is specifically under Pipeda. So personal information is about an identifiable individual and doesn't include their name, their title, or business address or business telephone number of an employee of an organization. So that when they say identifiable individual, we are looking at information that can be used to point out a specific person with the information that's out there. So anything other than those four things that are laid out specifically above, which come directly out of the privacy legislation, anything else would be considered personal information. So information about a health condition, your age, your gender, your personal contact information like your home address or your personal email address, all of that could be used to point out specifically who you are. So all of that is covered under Pipeda as personal information, and under Pipeda it is protected. So Pipeda has five main areas that it focuses on. The first is around consent for collection of information. So that means that as a business person, you can only take information if the customer or the client consents to provide that to you. And part of consent is understanding that why they're providing it to you. So if you, for example, are collecting information for an insurance application, you have to tell the client the reason you're collecting that information, most likely for underwriting and classification purposes for the insurance, and that information is a criteria for the insurance. If they don't agree to provide that information, you can't collect it. But the flip side of that would be if they don't agree to provide that information, you likely won't be able to complete the application. The second part of what we're going to look at is that personal information can only be released with the consent of the client. There are a few exceptions to this, but unless you have talked to the person who provided you the information and they've given you express authorization to give that information to someone else, you can't provide that information to anyone for any purpose. A best practice in this area would be to get written consent from them if you're going to provide that information to someone else, because if something does happen, you would want a position to fall back on if the client said that they didn't give you consent to release that information. The third piece of Pipeda is that personal information can only be used for the purposes that it was collected for. So if you are telling a client that you're collecting their information for the purposes of an insurance application, you have to use that information for the insurance application. If you're going to use the information for a different purpose, you have to let the client know about that, and they have to agree for their information to be used for that additional purpose. A good example from our industry in Business Career College would be if someone signed up for a course to qualify for their life insurance license with us. The information that we receive for that can be used to manage their life insurance course progress. But if they wanted to come back later on and do a financial planning course with us, they would have to provide that information to us with consent to use the information for that other purpose when they signed up for the other course. That's the reason that we, for example, get a student to fill out a new registration form each time they register for a course, so that we can be sure that a student is understanding why they're providing the information to us. The fourth part of the Act is the role of the Privacy Commissioner. And basically, what the fourth part of the Act says is that the Privacy Commissioner can investigate breaches of the Act. So they look into any problems that may come up in regards to a complaint or poor storage of information. And then, in addition to that, the Privacy Commissioner can audit personal information management practices of a business. Now, that doesn't mean that the Privacy Commissioner necessarily has access to anyone's specific private information. It's specifically the information management practices of a business. So what that means is the Privacy Commissioner can look at how you store someone's information, how you tell a person how you're going to use their information when you collect it, and how you dispose of a person's information once it's no longer needed in your system. Now, those three pieces are the key parts of what a business does with information. They collect information, and you always have to collect it in a way that's consistent with getting consent and the person understanding why they're providing it. How you store information, it has to be secure and it has to be retrievable. How you use information, again, only the way that the client has accepted that you'll use that information, and how you dispose of information. So it's equally important that once you're finished with using a person's information and you're no longer going to use it, you should be disposing of that information so that it can't be retrieved from your system maliciously. Now let's take a look back at the second criteria on this slide here, that personal information can generally only be released with the consent of the client. Now that's true, and that's the rule of thumb that you'll want to work with, that you should not be releasing information without a client's consent. But there are some very specific times in which you can release personal information without consent. So those exceptions are really, there's three exceptions that we're going to look at. And the first is that consent is not needed to collect or release information when it's part of legal proceedings. So if the police or the court system are requesting information or are collecting information about a person, they don't necessarily have to follow the same regulations as a business might need to collect that information. Because there's a legal proceeding involved, the person may not be as cooperative to provide the information and may hesitate to provide that information, so the proceeding couldn't be completed if full consent was followed in that case. A second illustration of that would be if the government is undergoing an investigation. So if they're collecting information on for example, a fraud claim against a government department, perhaps around the Canada Pension Plan, they also may have an exception to consent here that they could look at. The third area we're going to look at is actually a new development to note. An amendment to Pipeda received royal assent, which means it went through government in June of 2015, and that's called the Digital Privacy Act. So in this update, one of the key things that was put in place is a new exception to consent was added. And this exception to consent is around the insurance industry. And what it says specifically, I've copied it word for word into this slide here, is that information produced by a witness statement when the collection is necessary to assess, process, or settle an insurance claim does not require consent. So in those cases, you would not need consent if you were adjudicating a claim. Now, if you were releasing or collecting information without consent, because these are special exceptions to the law, it would be a good idea for you to seek legal advice or your company to have a legal position on this before you made an exception to this. I would never want to advise that in all cases that these exceptions are going to be upheld. And I am not a lawyer, so I wouldn't be providing legal advice here. So you'd always want to seek legal guidance if you were making an exception to consent. Now, I want to take a moment to pop back to the classification of personal information now that we're talking about consent for use, collection, and release of that information. If you have employees, the information of those employees is also considered personal information because you'd have access to information like their age, their home address. You may know about personal health considerations and so on. These same pieces of legislation would apply to you regarding that employment information. So employment information is collected to manage an employee of your organization, so you wouldn't want to use that outside of your organization. And if you wanted to use that information outside of your organization, you'd always want the employee's consent before you transferred any of that information. This is one of the reasons why often when someone is seeking a reference, you would ask for their agreement for you to contact previous employers about their employment history, because without their consent, those previous employers would be very limited in their ability to provide information. And really speaking, the things that they would be able to release are the things in this list that we see are not included as identifiable information. So that would be the name and title of the individual. So they could tell you perhaps that they worked for their company as an administrator, but beyond that, they may be very limited to provide you information without the consent of the employee. So looking back to the 5 points that Pipeda covers, we're now going to focus on the last 2 points, which are really about the role of the Privacy Commissioner under Pipeda. Like we said when we were discussing the Privacy Act, the Privacy Commissioner also is the person who's in charge of compliance with the Privacy Act, but now we're going to look at their role under Pipeda and what they can do and what their role is to make sure people are following the regulations that are set out under Pipeda. So the Privacy Commissioner does manage the regulations, and they can, if they have a violation brought to their attention, or if their department believes there's a violation, they can investigate that violation. There's a very detailed process on how they would handle an investigation. Once they complete their investigation, they will report that there is a violation. That is one of their responsibilities under the Act, is that they do have to report violations publicly. And additionally to that, they may suggest remedies. So when we talk about suggesting remedies, if they're investigating a privacy breach where you gave information out about one of your clients to someone without their consent, they may suggest, for example, that your business have a policy in place around when information can be released and how it would be released, and then keeping a record of that request on file. If it wasn't a breach of the act like that, where perhaps you accidentally released personal information about the client to someone that you thought was the client, they might then in that case suggest procedures that you can put in place to verify that you are in fact talking to your client before you confirm things about their personal information. This is one of the reasons that we see verification questions when we call into a service provider, because they want to make sure that you, in fact, are the client that they're talking to so that they can manage their privacy responsibility. Now, once this investigation is completed and the violation has been reported, and even if remedies are suggested, there's a second piece around compliance, which is outside of the realm of regulation by the Privacy Commissioner, but it's about the relationship between you and the client whose information we're talking about. So if you are maintaining a client's information securely, you're only using it for the purposes you collected it for, and you collected it with consent, and you dispose of it once you're done with it properly, then you shouldn't have any problems with the Privacy Commissioner or with any individuals. But if there is a problem in any one of those areas, an individual can take legal action against you if you're in violation of Pipeda. So, as we said, that would require first the Privacy Commissioner to review and investigate the violation in question and report that violation. Once it's reported, someone could take legal action based on what actually happened in the specific case. That person could be awarded financial damages that would have to be paid by you, the person who was improperly maintaining their legislation. So that's one of the things we'll look at later when we talk about compliance generally, is there's a financial penalty potentially for not following Pipeda. Not a financial penalty from the Privacy Commissioner. They can't issue you a fee, but if a person takes you to court and it's found that you did not protect their information well enough, you could end up with a fine due to that. So let's take some time now to look at some of the easy things that we can do to prevent problems with Pipeda. So some of our first category of best practices is around protecting the information. You always want your business's information to be secure, but when we're talking about that in terms of Pipeda, we want personal information that you've collected from clients to be protected. So if you took it in a physical form, if you were taking notes as part of taking an insurance application, you would want to make sure that you keep those physical files in a secure location. So that should mean that the files are put away when you're not using them, and at the end of the day, they're locked up so that no one can get access to them after business hours. During the day, if the area where the records are stored is supervised, it may not need to be kept locked. But if it's in a public area, you may want to keep that locked all day, not just at the end of the day. When we look at electronic information, the first step is protecting the device where the information is stored. So your computer should have a password. One of the reasons for that is that that's the first line of protection for the personal information. And inside the computer, whatever database that information is stored in should also be password protected. So even if it's a simple electronic place you're storing the data, so if you save it in a Word document and it's personal information that's stored there, you should apply a password to that as well, just so that that person's information is protected and you're respecting their privacy. This is also important when we look at removable hardware. So that means things like external hard drives or memory sticks. So if you're moving information from one computer to another using this removable hardware, that removable hardware, if possible, should be password protected. And then the documents within that, or the spreadsheets within that, should also be password protected. Now, these days, I more and more am sending information electronically, and it's important to keep that electronic information secure. So if you store information in the cloud with a service such as Dropbox or another private file server that's accessible online, you should always have a password to sign into those, and you should regularly keep those passwords secure. So that means things like not using simple passwords and changing your password regularly. The other way that we often send information back and forth is through email. Now, I know firsthand from emails that I've received, and unfortunately from the occasional email that I've sent, that if you're in a hurry, it's pretty easy to send the incorrect email or the correct email to the incorrect contact. So my name's Colin, and I deal with a service provider who also has a Colin that works on their staff, and sometimes accidentally I'll get an email intended for that other Colin. Now that could end up with a breach of personal information. So it's incredibly important that before you send an email, you do a quick read through that email and make sure that you're sending the right email to the right person. So you're reviewing your who you're sending it to, make sure that you're only sending it to the people you're intending to send it to, and then take a quick read through the email as well to make sure that the information that you're sending is all correct. So that if it has personal information, it's only personal information that the people in the email should be able to see, and that it isn't information about someone else that they shouldn't be able to see. Another quick tip that can help protect you somewhat if you do send an email accidentally is including a footer in your email. So the footer I've included here is just one example of what you might want to use. This is taken from a best practices site on privacy. So what it says at the bottom of the email is this email may be privileged and or confidential, and the sender does not waive any related rights and obligations. If the reader is not the intended recipient or agent, please be advised that any dissemination, distribution, or duplication of this email or any of its attached documents is strictly prohibited. If you receive this email in error, please return the message to the sender by replying to it and then delete the message from your computer. So that is somewhat of a complicated message, but really it's saying a few key things to you, to your client, and to everyone that received it. So the first line is saying that the email might contain privileged information. So you're asking them, please be careful with this email. And you're also saying that it should not be disseminated, distributed, or duplicated. So you're saying that you want them to protect the privacy of this person as well. And then, and the last part of it, you're putting a call to action there. So you're saying, if I sent you this email in error, let me know that I sent it in error so that you can follow up regarding this. And then you're asking them also to delete the message. So that's some of the technical things that you personally could do to help you follow Pipeda. Next, we're going to look more at the whole business side of things in creating a culture of confidentiality. What this means is creating an environment in your workplace, even if you're an office of one person or an office of 600 people, where confidentiality is viewed as a very important part of the business. So the first thing, and this is actually links back to restrictions that are in place under Pipeda, is you should have a privacy officer. So everyone under Pipeda needs to have someone that's in charge of privacy issues. Typically, it's someone in a more senior role in the organization. And basically all that means is someone who's in charge of making sure that Pipeda is upheld. So if you're a private business person who you're the only employee, you are the privacy officer, so you're the one in charge of making sure that Pipeda is upheld. If you have multiple people, you may want to appoint someone else. Now, it doesn't have to be named a privacy officer, but when you call someone a privacy officer, it creates the impression that privacy is important to your organization. And that goes to take steps in direction of making people understand that confidentiality is an important part of the culture of your business. The second step is making sure that everyone's training includes training on confidentiality. Now, that doesn't specifically mean any technical training on Pipeda, but it does mean that you should be making everyone in your organization aware of why confidentiality is important, what the benefits of maintaining confidentiality are, and what the consequences of lacking confidentiality might be. That doesn't necessarily mean the consequences of a breach of Pipeda. That could mean what your company will do if there's a breach of confidentiality. So by putting in place breach of confidentiality measures within your company's policies and procedures, you're telling your employees that confidentiality is important. Now, beyond that initial training and the policy work that we talked about there, you also regularly want to review confidentiality and privacy issues. So on a regular basis, you want to look at regulatory changes that are out there. Now, a good example would be the Digital Privacy Act that I talked about, which was just passed last year in 2015. If I had worked based on my resources from 2013, I wouldn't have known about the changes due to that act. So it's very important on a regular basis for your privacy officer to be aware of any changes to the legislation that's out there, and then to regularly communicate those changes to everyone that needs to know about those specific technical regulatory changes. And then equally important is doing a refresher training on confidentiality and privacy to all of your employees, even if there aren't any changes. So if every year you get people to review confidentiality and review privacy, every year you're telling them confidentiality is important to us. Yes, I know you may have seen this information before, but it's still important for us in maintaining confidentiality of our clients.